Okay, this is part 8. We're still working our way through the argument section of this appeal, and we're on part D. Judge Udovic erred by ordering defendant-appellant to a bench trial without conducting a probable cause hearing to determine if the warrantless seizure of defendant-appellant by Officer Clarence Davies was lawful, and also without conducting an arraignment hearing or obtaining the knowing waiver of said hearing by defendant-appellant. The record on appeal docket shows that at no point in time was a probable cause hearing held to determine the validity of the warrantless seizure of defendant-appellant by Officer Clarence Davies. The official transcript of the December 15, 2016 hearing included with this appeal shows that Prosecutor Evan Smith did not enter any oral charges, and there was no entry of a plea by defendant-appellant or the court. The ROA docket number 25 also shows that on March 2nd, 2017, defendant-appellant was ordered to appear for a bench trial on June 15, 2017 at 2 p.m. in courtroom 2C. This is a violation of process. The commencement of prosecution by the entering of charges, an arraignment, and the entry of a plea is required before proceeding to trial. It's unfathomable that a judge would set a trial date when a record clearly reflects no entry of charges and no entry of a plea. Do I really have to point that out? I mean, come on, guys. Okay, and in my prior video, the part 7, I did have that right. It's Rule 12 that you want to look at. So see Rules of Penal Procedure, Rule 12A, the use of the term shall in HRPP Rule 12A. Pleadings in penal proceedings shall be the charge and the pleas of not guilty, guilty, and nolo contendere indicates the mandatory requirement of these things before trial. Okay, and note that it's shall, that's mandatory. It doesn't say may. And then the other issue is the charge. Okay, now obviously we can't expect somebody to enter a plea if they don't have a charge. So that's a pretty short section, but the points are just solid. I mean, it's like, again, we're dealing with foundational issues here. Alright, I think we can finish this. I take that back. Alright, we'll have to break this up, but I'll try to make it through this section here. There's a lot of sites here that I'm going to read for you that are very important, and they just, you know, they buttress the points I'm making here with the statutory code that I'm citing. Okay, Part E. Judge Freitas and Udovic erred by failing to acknowledge that only a licensed prosecutor may initiate prosecution for a criminal case, and a police officer is not a prosecuting officer. This is a due process violation. As explained supra, that's Latin for above, the trial court should have found that, as a matter of law, HRS 28-1 and 28-2, not HRS 803-6B, which is a section on arrests, and these are sections defining job duties, were the laws that regulated who shall initiate prosecution on behalf of the people of the state of Hawaii. But even if the court below mistakenly thought that HRS-6B applied, the court's dismissal of defendant-appellant's motion to dismiss is an error. HRS 803-6B does not allow for a police officer to initiate a criminal proceeding in the name of the people of the state of Hawaii. This would be in violation of HRS 28-1, HRS 28-2, HRS 605-2 and HRS 605-14. I believe this one is you have to be licensed to represent somebody, and the party being represented would be the state of Hawaii. So the cop does not have a license, and don't quite remember, but it's definitely tied in with prosecution, so look that one up yourselves. Actually, I might cite them in here somewhere. Specifically, HRS 803-6B, as applied to allowing a court clerk to create a criminal case upon the filing of a citation by a police officer, violates the requirements of HRS 28-2, HRS 605-2, HRS 605-14, whereby only a licensed prosecuting attorney has the discretion to initiate a criminal case by filing charges with a verified complaint with the court clerk. Okay, this is a case cite and support here. And this, let's see, it's a long one. It's this. And they actually cite, because Hawaii is considered young in terms of the case law, here, they cite other states on occasion for reference. And the whole point being, the other states are essentially doing things for the same reasons that they are. Police officers are not prosecuting officers within the meaning of HRS 701-1092. Boom, right there, that's it. Okay, that is my point. So they cannot initiate prosecution, period. An Illinois appellate court has held that proper prosecuting officer, as used in a statute similar to HRS 701-1092, does not include police officers. In People v. Pohl, an Illinois appellate, let's see, 2nd District, the defendant entered a plea of guilty to the offense of driving without a valid driver's license and was assessed a fine, which he paid. Take note of the date here. Okay, this is well-established law. Prior to the entry of the guilty plea, the defendant advised the court that his driver's license had been previously revoked. The state's attorney thereafter filed an information charging defendant with driving a motor vehicle when his license was revoked. Defendant was convicted and sentenced. On appeal, he argued that his disclosure of the revocation of his license to a state police officer was knowledge to a proper prosecuting officer within the meaning of the relevant statute. The court concluded that the proper prosecuting officer referred to the state's attorney and his assistants, and not to state police officers. This is another cite out of Illinois. Not terribly important for us over here. You wouldn't want to cite that directly. You'd want to cite the Hawaii site that refers to it, like I did. Such an interpretation of the prosecuting officer is consistent with the dictionary definition of prosecutor. Thus, Webster's Third New International Dictionary defines prosecutor as a person who institutes an official prosecution before a court, often by appearing as the chief witness before a grand or petite jury or before a magistrate. However, a police officer is defined in Black's Law Dictionary as one of the staff of men employed in cities and towns to enforce the municipal police, i.e., the laws and ordinances for preserving the peace and good order of the community. Clearly, a police officer does not, nor is he authorized to, perform the function of a prosecutor. State v. Solomon. Since the prosecutor is generally charged with the responsibility of determining whether or not to instigate a formal criminal proceeding, see Ememia v. Sapienza, and this is out of the Hawaii Supreme Court. Anytime you see the citation like this, it's from the Hawaii Supreme Court. So this was a Hawaii Supreme Court ruling up here where they referenced out of the state, which means you want to reference them, the Hawaii Supreme Court, when you're doing anything in Hawaii. The public prosecutor has been delegated with the primary authority and responsibility for initiating and conducting criminal prosecutions within his county jurisdiction. The absence of the prosecutor's signature in a complaint, in our view, is not a mere formal defect. So, again, on the Big Island of Hawaii, the Big Island itself is the county of Hawaii. We have a prosecutor here. He's pretty corrupt, or was pretty corrupt. He's now our mayor. Isn't that lovely? Number 4. The prosecuting attorney has broad discretion to initiate criminal proceedings, to decide when charges will be filed, what charges will be filed, how many charges will be filed, under what statutes the charges will be made, and when the proceedings will end. That pretty much sums everything up right there. It is well settled that an accusation must sufficiently allege all of the essential elements of the offense charged, a requirement that obtains whether an accusation is in the nature of an oral charge, information, indictment, or complaint. State v. Gendrish. This one is cited in a ton of cases that involve insufficiencies of alleged charging instruments, either documents or through the oral charge. This entire section. Put differently, the sufficiency of the charging instrument is measured inter alia by whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet. A charge defective in this regard amounts to a failure to state an offense, and a conviction based upon it cannot be sustained, for that would constitute a denial of due process. That's me, and I raised this issue of being denied of due process during at least 2 or 3 interlocutory appeals, but the appeals court here in Hawaii, the Intermediate Court of Appeals, refused to hear it. They didn't want to touch it. They were hoping things could get resolved or I could get worn down at the lower court. I'll do videos on those filings at some point. Whether an indictment or complaint sets forth all the essential elements of a charged offense is a question of law, which we review under the de novo or right-wrong standard. Okay, I think I'm going to stop this right here and we'll make a separate video for the remaining 2 elements. If you like this, please give it a thumbs up, subscribe, and almost more than anything else, share it. Just try to get this info out there so that the general gullible public will maybe start to get a clue that the courts cannot be depended on. There's plenty that already understand this. They've either been burned by the stove or know others that have, but there's also plenty that have no idea. They haven't been injured yet. So until next time,